My name is Natasha Arnpriester. I'm a third-year law student here at Penn Law, and I'm interested in international human rights law.
And I'm Patricia Sellers. I'm a special advisor to the International Criminal Court and a professor of international criminal law at Oxford University. And I'm from Penn, year 1979.
So thank you for being here today. I know you recently accepted an award at the Penn Law Inaugural Women's Summit, so we appreciate you being here.
Thank you.
I just had a couple questions for you regarding your work and your view of international law and women's role in it. First, I wanted to ask you about the international landscape. And we have all these different declarations and Security Council resolutions and conventions on women and also on sexual violence against women. Unfortunately, sexual violence is still happening on a widespread scale. So what do you see that international law can do, and international law actors, legal actors in particular, to help prevent this?
Well, I think, first of all, it's good that we have those laws, those declarations, the resolutions. And as in domestic law, we have laws against murder. That doesn't mean that murder stops. Right. And we have laws against parking tickets. It doesn't mean, you know, parking illegally doesn't stop. But the fact that we didn't have explicit laws outlawing sexual violence during armed conflict or as part of genocide or part of human rights violations gave the impression, even though it might have been incorrect and not incorrect, illegal, gave the impression that these violations were not outlawed. And so it's very important right now in the legal landscape that we do have the declarations, the conventions, the resolutions, and more than that, the policies around them so that they can be enforced, and the judicial mechanisms and the political will to do that.
So I'll move to your current role as special advisor to the International Criminal Court. Very recently, we just had a case come down against the former Vice President, Jean-Pierre Bemba, and he was found guilty of war crimes and crimes against humanity under the concept of command responsibility. And I was hoping you could speak a little bit about the case and what this means for victims of sexual violence moving forward, and maybe more generally the implications of this case on the concept of command responsibility.
Right. Jean-Pierre Bemba was the Vice President of the Democratic Republic of Congo. He was found guilty for crimes committed in the Central African Republic. So first of all, it's very important that we have a politician of one country who is the head of a militia, who has now been convicted for committing crimes via his militia in a second country. We often don't have that in domestic law. And the crimes that he was guilty of committing was rape, as both a war crime and a crime against humanity, but also murder as both a war crime and a crime against humanity. Now, he didn't physically kill anyone, he didn't physically rape anyone. His subordinates did. And he was found guilty because his subordinates were under his effective control. They had a pattern of illegal conduct that he failed to prevent and he failed to punish. So that's how the command responsibility liability mode worked toward his eventual conviction, being found guilty. For the victims, I mean, what can I say? This does not bring back their life as it was. But what this has done has given them access to a remedy, which is a human right, access to justice, and there is always a sense that we know when you win your case, when you've been vindicated, when you understand that what happened to you was a crime and that that person is responsible for the crime, you are allowed to breathe deeper and start to put a part of your life back together to go forward. So this is very important. In addition, right now, the trial chamber must come forward with two other decisions. One will be on sentencing, and the other will be on reparations. It will be the first case under international criminal law where sexual violence will be part of the reparations of the case. Under a former case, Lubanga, even though there has been sexual violence, the reparations in terms of sexual violence was not included because Mr. Lubanga was not convicted of sexual violence due to the liability mode, due to the charging. And in the subsequent cases of Katanga and Chu, where sexual violence was committed, the accused were not connected to that sexual violence via a liability mode. So for the Bemba case, it's the first time we'll have reparations related to sexual violence because the accused has been found guilty of the sexual violence. It's monumental.
Yeah, thank you for explaining. You actually spoke in a panel just recently about using use cogans and rape, and why rape has not risen to the level of use cogans. And I was hoping you could speak a little bit more about your thoughts on that.
Right. Your first question was about we've outlawed rape. It's in declarations, we have it in some of our conventions, we have it also within resolutions. And one would then wonder, since sexual violence, but in particular rape, has been outlawed in international criminal law, are there any exceptions? Are there any times when you can use rape, such as with killing? Even during war, there can be legitimate killings. You can legitimately destroy a building. But there's some values under international criminal law and international law that you can never do. And there's not supposed to be any exceptions. Among those is torture. You cannot advocate for torture, and you cannot commit torture and claim an exception. Another is slavery. Another is piracy. Genocide, crimes against humanity, and war crimes are not supposed to have exceptions because they have what is termed use cogent value, or peremptory norms. And under the Vienna Convention on Treaties, Article 53, a peremptory norm, use cogent, is the highest value of international law. And it can never be replaced by anything unless it is a higher value. Now, rape, even though it has been outlawed, and even though I can't think of an exception under international criminal law when it is permissible, when the exception can be invoked, has never been considered having use cogent value or peremptory norms. And so I would ask, well, why not? And it's not exactly that we want rape to be seen as being as strong as slavery or piracy, but I think its legitimate due under international criminal law is to be given the value that corresponds to the violation to which no exceptions exist.
All right, so I'd like to ask you a more general question regarding women in international law. What's your vision for how women can play the most impactful role in international law and its shaping for a more just world?
Well, I think female attorneys have a crucial role in international law, and it's just being excellent lawyers. It's bringing their own personal perspective to the exercise and the practice of international law, and particularly international criminal law. I think that for many years we think of international law as something that's done by patrician-looking men, you know, discussing seriously and you know, drafting these international treaties. And women, who are one half of the international community, have to participate if we want international law to respond to our lives. I've met excellent female judges, female investigators, female prosecutors, female defense attorneys, and to think of what international, and particularly criminal law, would be like now without their participation frightens me. So I think that we bring a rigorous approach to the law in any field that we go into. We bring ourselves to the law, and we understand that we are part of the subject of the law and the actor of the law. And that's what I would want for women.
Thank you. And as a lawyer and as a woman in this field, could you tell us a little bit more about your path and how you got to where you are today?
Well, I'm from the Philadelphia area. I grew up in Camden since I was 8 years old. And I had always wanted to be a lawyer. I didn't want to be anything else. Maybe that was a lack of, vision, but that seemed to satisfy me. And as I was growing up, I was heavily influenced by being in a family where we discussed racial justice. My mother was a teacher. My father worked for the county and been an Army officer. And so politics and justice were things at the dinner table was meant to entertain. After I finished high school, I went to university, Rutgers College. I was always back here during the summer times and worked in the Camden jail system doing fingerprints, and realized that I probably really did like criminal law. So now I knew I wanted to be a lawyer, then I knew it was going to be criminal law. And I also started volunteering once I got into Penn at the American Friends Service Committee. And Philadelphia has a very deep Quaker tradition, and the American Friends Service Committee is actually the kind of like part of the Quaker Church that does social justice projects in the United States and around the world. And I worked with them on their Latin American programs, and they sent me to Puerto Rico, to other parts of Central America. And so by the time I went through Penn Law School, I was able to turn that way of combining social justice domestically from my parents with some international social justice from the Quakers. And Penn provided us the opportunity to take the third year off and go to Washington to the Center for Justice and Social Policy. And so I did that. And I did an internship that was centered around mental health. And it was the epic of kind of deinstitutionalizing people from mental health institutions in the late 70s. When I left the law school, there was only one job that I really wanted, and it was to be a public defender, because I wanted to be in court and be fast on my feet and all of those things. So I joined the Philadelphia Defender Association and spent 3 years litigating everything from attempted murders and rapes and burglaries and really enjoying the practice of criminal law. And then I had a chance to accept a job outside of the country in Brazil with the Ford Foundation to set up their human rights program as it related to women and as it related to some impoverished communities. When I went to Brazil, I was struck by the fact that it was a very exciting political moment for them. They were coming out of the dictatorship and getting ready to go back into a democratic form of government. And at that conjuncture, you had several groups that were starting to form who the Ford Foundation programs could assist. And they were women's groups, and they were Afro-Brazilian groups. And because I'd had a background looking at social justice and looking at African-American social justice, looking at the Brazilian, Afro-Brazilian social justice, it was not the same conversation, but a very related conversation. And that was quite rewarding to me. And then looking at women's rights coming out of a dictatorship, and particularly women who had been jailed and who had been tortured and now were vocalizing their needs under domestic violence to end, or health and reproduction. So things kind of gelled together. And then I met my future husband, who was Belgian, and I moved to Belgium. That was kind of unplanned to a certain extent. And after being in Belgium for several years, I mean, I tried certain jobs, and I wasn't necessarily, they weren't legal jobs. I wasn't excellent in those jobs. One was to be an accountant at Price Waterhouse. That was not the highlight of my career life. And then I joined as an assistant one of the European Union desks for Thailand and Burma, where I basically used my political science background. That was extremely interesting. I got to understand Asia and some politics. But then lo and behold, they were setting up something called the International Criminal Court for the former Yugoslavia. And I read the statute and realized this is my chance to get back into criminal law. And by that time, my international experience really kicked in with my criminal law experience. And when I joined that tribunal, almost at its very beginning in 1994, and I was excited to start investigating again and going into court, the prosecutor and the deputy prosecutor approached me and said, would I handle the portfolio that dealt with women and sexual violence due to my work in Brazil? And so I did. And it was my job to look at investigation and legal investigation strategies and legal strategies on how would we really implement this mandate, our statute, where rape was seen as a crime against humanity. And we interpreted acts of sexual conduct such as rape both into war crimes and eventually into genocide. And the tribunal, the Rwanda and Yugoslav tribunal, for a time period were joined, and that's how I was able to work in both of those. And I stayed there for 13 years, and in addition started doing teaching and then working with groups and governments around the world on this issue. So I won't say it's a straight path, it was my path.
Going off what you said about your transition from doing domestic work into the international sphere, I wanted to ask you about the issue of civil rights and it looking more as a domestic concern, and then human rights seeming more international. And if you see a connection there, and if so, if you could explain that.
Well, I definitely see a connection between civil rights which are basically referred to in the United States as a type of domestic rights, and human rights, which is usually seen as international human rights. In many ways, they're both the same thing. In civil rights, you might have the right to vote is protected, the right to your political participation, the right not to be brutalized by the police. And when those brutalities do happen, you can sue the government for your civil rights. I mean, there's a lot of the Department of Justice has a whole division on upholding your civil rights. Well, that's the equivalent in the international sphere of upholding your international rights, where the state has the obligation of due diligence to protect your international human rights, to promote them, to enforce them. And when there's a breach of their due diligence, you have a right to not only sue that government. If that government isn't responsive, you can go to international mechanisms, whether they be regional, a regional human rights court, such as in Europe or in Latin America, or you can go to treaty bodies under the United Nations, such as your treaty body for the Covenant for International Civil and Political Rights, or CEDAW, the Convention for the Elimination of Discrimination Against Women. So really it's more than just terminology. I'm not going to say it's just a matter of terminology, but the thought process, the policy basis is almost the same, that government should hold up certain rights for their citizens, and even some of their non-citizens, whether they're refugees or whether they're aliens.
Well, thank you. Thank you for answering these questions and being an inspiration for both lawyers and women generally in your quest for international justice.
Thank you very much. My pleasure.
Thank you.